In a matter of days or weeks, Ripple and the SEC might start their transaction. A consensus is likely to be reached. On the other hand, recent developments in the legal fight between Ripple and the United States Securities and Exchange Commission offer hope for a resolution. The process of drawing sketches. John Deaton, the person who made cryptographic legislation possible, is a significant figure in history. His arguments have the potential to materially affect the case. That Ripple might not be required to pay the $770 million in fines is one of the most significant revelations that Deaton has made. On top of that, the SEC has taken into consideration legal difficulties in a number of countries, including the United Kingdom. Considering that Purchase is investigating the disgorgement of XRP sales by the Securities and Exchange Commission, SEC, Deaton is of the opinion that SEC might not be permitted in Japan and Switzerland. This is due to the fact that sales made on a global scale are not subject to the Morrison Rule that the Supreme Court established. In addition, Deaton notes that the government agencies in the United Kingdom and Japan do not consider XRP to be a form of protection. The cryptocurrency known as XRP is not classified as a security token because it is a trade or utility token. As a result, the SEC will have a difficult time receiving criticism in these areas. As a result of the fact that selling XRP is legal in many places and supported by government entities, the legal case against it is now less compelling. In his opinion, a fine of $770 million is quite improbable. This is the reason why, even though they make up more than 90% of the overall disgorgement, sales to allowed investors located outside of the United States could be removed from the final total. Ripple could be penalized $20 million for XRP demand liquidity trades, according to him, who is positive about the situation. An expert in the law provides specifics and underlines how quickly these transactions take place. According to Deaton, the fact that ODL trades rarely result in injuries may be a factor that undermines the SEC's case. According to him, the 75,000 owners of XRP who signed the lawsuit will point the finger of responsibility at the SEC rather than at Ripple for any potential damage. In his argument, Deaton suggests that the judge might be obligated to pay Ripple money if the $150 million in legal fees that the company has already incurred are either added to or deducted from the lawsuit. Dean is of the opinion that the Securities and Exchange Commission, SEC, would be taken aback by the fact that overseas sales are permitted to allow investors and ODL transactions. The Supreme Court's Ripple decision, which states that disgorgement cannot exceed net sales profits, served as the basis for his argument. In order to accomplish this, he brings up the fact that the legal counsel is responsible for informing the founders of the SEC arrangement prior to the case being resumed. It has been revealed by the chief lawyer for Ripple that the SEC is taking steps to corner the coin sector. A quick settlement was provided to Ripple by the SEC. Earlier, the commission was the primary center of attention, but this is not the same. The justification for this adjustment is not the most compelling one. Ripple's representative, Stuart Alderodi, stated that the Securities and Exchange Commission, SEC, made a settlement offer to a cryptocurrency company prior to the filing of the lawsuit. Ethereum's developer, Vik, is selling tokens worth $1 trillion. Ripple's chief legal officer claimed that the SEC had told the cryptocurrency company that XRP would be classified as a security as part of the settlement. This information was contained in the statement. Initially, the commission intended to grant the market a brief grace period to comply with the regulations. However, Ripple decided to file a lawsuit against the cryptocurrency authority instead. I will also take a risk and explain why Ripple chose this alternative rather than one that was less expensive. Following their demonstration that XRP was not a security, the cryptocurrency corporation was able to achieve this goal, as the SEC did not need them to have a crypto compliance framework. They stated that this was the reason why they did what they did, and the outcomes demonstrate that they were correct.